What exactly are you wearing?
I'm sorry.
You look like you have a swimsuit on to me.
No, it's not a swimsuit, and I did not know this was a court day. I just told the lady back there that I'm not dressed properly for court at all.
Really? Yes, you are not. I agree with that 100%. That's very insulting to me, that you would come into my courtroom dressed like that.
I apologize.
The court case shows a tense courtroom moment where a judge confronts a defendant, Monique Smith, about her inappropriate attire, which resembled a swimsuit. The judge expresses strong disapproval, emphasizing the importance of respect and proper appearance in court.
I had no idea it was in as a visit and not a court day. So I was unaware that this was a court day. Because she wrote on the back of the car, a visit. So it was never said that this was a court date.
All right, this is case number 23CR 40542, the state of Ohio versus Monique Smith. Ms. Smith, the court has received a report that alleges that you have violated the terms of your ILC. Officer, statement of the allegation, please.
Yes, Your Honor. Ms. Smith has violated ILC condition number 1, and then on June 11th of 2025, the defendant pled guilty to and was sentenced for 1 count of OVI and 1 count of driving under suspension. This was in Middletown. And then on June 11th, the defendant pled guilty and was sentenced for another count of driving under suspension under a different case number, also in Middletown. On December 10th, 2024, the defendant pled guilty to and was sentenced for 1 count of driving under suspension, or under an OVI suspension under a case in Middletown. And on July 12th, 2024, the defendant pled guilty to and was sentenced for 1 count of driving under suspension. As well as ILC condition number 8, the defendant has failed to inform her probation officer of law enforcement contact after picking up a new OVI charge and another traffic offense on March 24th of 2025. Special condition number 16C, the defendant failed to complete drug or alcohol treatment as ordered on February 1st of 2024. Special condition 16D, the defendant has failed to complete mental health treatment as ordered on February 1st, 2024. Special condition 16E, to date, the defendant has failed to pay restitution in full as ordered on February 1st, 2024. And finally, special condition 16F, to date, the defendant has failed to obtain her GED as ordered on February 1st, 2024.
Ms. Smith, do you understand those allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you. Do you have the funds to hire an attorney?
I do not.
Do you want me to appoint you one?
Yes, please.
Mr. Mall's handing you an affidavit of indigency that you need to sign.
Okay, right above my name.
Why is she not in custody?
Your Honor, Ms. Smith, despite her non-compliance with court orders, she has continued to drug test negative. And she has appeared for order to reports after they were issued.
All right, the court will find that you're indigent for the purposes of retaining counsel. The court will appoint attorney Roger Bouchard to represent you in this matter. The court finds that there's probable cause you have violated the terms of your ILC, and this matter is going to be set for final hearing. Ms. Smith, I don't know what you expect. Looking at your record, this isn't your first contact with the court, but I'm not sure what you've expected or what you have done in other courtrooms, but this is very different. I'm going to hold you to what I ordered you to do.
Yes,
so
sir.
you owe significant amount in restitution.
It's $11,433.
You have been on ILC for over a year.
Monique claims she was unaware it was a court date, thinking it was just a visit. However, the judge is firm and highlights Monique's serious legal troubles, including multiple violations such as driving under suspension, failure to complete court-ordered drug and mental health treatments, and failure to pay restitution. Despite being on supervision for over a year, Monique has made little progress, owes over $11,000 in restitution, and faces strict warnings from the judge.
You have not done anything, and you continue to break the law. The next time you appear before me, you better have a solid plan in place or you are going into custody. Do you understand me?
Yes, sir.
You owe $11,000 to the victim in this case. You don't seem to care that I've ordered you to do things. You come to court dressed very inappropriately, and I'm telling you right now, I don't know what your contact with the court has been in the past, but it's going to be different when you come in here to see me again. Do you understand me?
Yes.
Because the next time I see you, if you haven't done something, you are going into custody. Are we clear?
Yes, sir.
All right, that's all.
The judge sets a clear ultimatum. If Monique does not have a solid plan and show improvement by the next court appearance, she will be taken into custody. The judge makes it clear there is no tolerance for disrespect or neglect of court orders in this courtroom, leaving Monique with a stern message about consequences if she fails to comply next time. This dramatic courtroom scene highlights the seriousness of legal responsibilities and the judge's commitment to enforcing them.
This is, you step to the podium, please. This is case number 25CR42474, the State of Ohio versus Michaela Wells. Ms. Wells is before the court with her counsel, Mr. Niehaus, Ms. Tranter, on behalf of the State of Ohio. First off, Mr. Niehaus, with regard to your motion for intervention of conviction, the court is going to deny that motion. Ms. Tranter.
Your Honor, with the denial of that motion, it's my understanding that Ms. Wells is willing to change her plea to guilty this afternoon to a felony of the 5th-degree theft.
Next comes Michaela Wells, who is represented by counsel and enters a guilty plea to a 5th-degree felony theft charge. The court reviews her understanding of the charges and rights, and the facts outline that she took merchandise valued at $2,483 from a cosmetics store. Michaela has prior theft offenses and probation violations, including drug use, which the judge highlights as concerning for her future. The judge issues a firm warning about the seriousness of her offenses and the consequences of continued crimes, insisting on restitution and compliance to avoid custody.
So you can read and write. All right. Mr. Niehaus, is that accurate?
That is our understanding.
All right, Ms. Wells, you're telling me you're going to change your plea to the one count of the indictment. Before I get to your change of plea, I'm going to go over some things with you, okay?
Yes.
How old are you?
18.
How far did you go in school?
I graduated.
So you can read and write?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this case?
No.
Is that this document says that you're entering a plea of guilty to one count of theft as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $1,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes.
Ms. Tranter.
On or about October 28th, 2024, Warren County, State of Ohio, the defendant, Michaela Wells, did with purpose to deprive the owner of property, knowingly exerted control over that property without their consent. This was a theft from Ulta Cosmetics in Deerfield Township. The amount of the merchandise was valued at $2,483.
Mr. Niehaus, anything on those facts?
Waive and stipulate.
Ms. Wells, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Ms. Wells, I know you didn't come down here today this was an ILC hearing, so I am going to allow Mr. Niehaus to schedule this at his convenience over the next several weeks. Now, just so that we're clear, you are 18 years old, you have theft charges pending in Butler County, Cuyahoga County, you're on probation in several counties for theft offenses. This is not a good start to your life, adult life, I should say, is it?
No.
So either you stop stealing or you're going to spend the rest of your life in and out of jail. And I don't know how to get through to you. I appreciate the fact that you were here on time. In fact, you were here early today. I told you last time you needed to be more respectful with regard to that, and you responded. But then you still tested positive for marijuana, which I told you were not allowed to use as a condition of your bond. Now, between the time between the time of now and the time that you come back for sentencing, there's a couple of things that I would recommend to you if you don't want to go to jail. Because quite frankly, I don't like people to come into my county and steal from other people. Have you ever had something stolen from you?
Yes.
It's not a very pleasant thing. Something that you own, that you've worked for, that you've earned is taken from you by someone who did not earn it. That's very bothersome to me. So there's several $1,000s in restitution that's owed. If I were you and I didn't want to go into custody, I would do everything I could to get that restitution paid in full before I came back. And I'd stop smoking marijuana because the judge told me I wasn't allowed to do it. That's just me. You can make your choices. You're now an adult. But when you make bad choices, you understand there are consequences. We clear on this?
Yes.
All right. I'm just giving you some advice to maybe keep you from going into custody because, quite frankly, at this point in time of your life, you're not in juvenile court anymore. Consequences are more severe. And in this county, I will hold you to those consequences. Okay? I don't know what your experience is in Cuyahoga County where I don't know if they forget about you or what. I'm not going to forget. Okay?
Yeah.
All right. Do what you got to do. I'll see you in a few weeks.
Thank you, Your Honor.
Thank you, sir.